Welcome back to Counting to Five, a podcast about the United States Supreme Court. I'm Mike, your host. This is a special YouTube live stream being broadcast live Monday, June 25th, 2018 at 9 p.m. Eastern Time. This live stream will also be posted as an episode of the Counting to Five audio podcast. So since the beginning of January, I've been holding these live stream broadcasts every week on Thursday evenings to keep up to date with the latest Supreme Court news. And usually every Thursday we've been covering a week's worth of Supreme Court news, opinions, whatever's going on at the court. However, we're now right in the middle of the end of term rush as the court tries to get all of its pending cases decided and opinions out before the end of June, and there's just a lot of material coming out of the court. Last week, last Thursday's live stream ended up running extremely long, so to try something a little different, I'm trying to break things up this week, and I'm going to have a couple live streams, each one covering less material to try and make it a little more manageable. So just to bring us up to date, last Thursday, I covered the opinions that were issued on Monday and Thursday last week, and the court had decided 9 cases between those 2 days. The court met again on Friday. They sat on the bench again on Friday to issue additional opinions and handed down 4 more opinions on Friday. Now, those 4 opinions from Friday are the opinions that I'm going to cover in tonight's live stream. And just to kind of finish the story of where we stand in the term right now. After those 4 opinions that were issued on Friday, the court had 6 opinions still left to be issued and was scheduled to issue opinions this morning, Monday the 25th. This morning, the court issued 2 of those remaining 6 opinions and announced that it will be sitting again tomorrow to issue more opinions. Now, the court usually indicates when the next opinion issuance is going to be the last of the term, and they did not do so for tomorrow. So we're expecting some of the remaining. Again, there's 4 opinions left to be decided. Some of those remaining opinions we're expecting tomorrow, that's Tuesday, and then presumably at least 1 or more of those opinions will be coming on another opinion day later, hopefully Wednesday, but we won't know until tomorrow when the next opinion day will be. So again, 2 opinions were released this morning. We're expecting more tomorrow morning, and then the court will finish out probably on Wednesday or Thursday, but we don't know for sure. So the plan right now, the tentative plan is, again, tonight in this live stream, I'm going to cover the 4 decisions that came down on Friday. I'm not going to touch on today's opinion. We'll have to wait until later. Today's 2 opinions, we'll wait until later in the week for that. Hopefully, if the court wraps up all its opinions by Wednesday, then I'm planning on Wednesday night to do an episode just devoted to those 6 opinions that will come down this week, this morning's opinions and the rest of the opinions, assuming they all come down by Wednesday. So that's the plan, hopefully for Wednesday night. And then Thursday night, that's my normal weekly time. I'm going to kind of do a little wrap up of the term and look forward. And in that one, I'll also look at the court's new grants. The court granted 7 new cases this morning, and we'll talk about those. And then other orders and other news about the court in the last week. So that's the plan. Tonight we'll cover Friday's opinions, and then Wednesday and Thursday we'll wrap up the rest of the week's news and kind of close out the term. So. Without further ado, I think I'm going to just dive right in to the 4 cases that came down on Friday. And the first of those 4 is a case called Western Gecko v. Ion Geophysical Corp. And this is a patent case. And specifically, it's about the availability of patent damages for lost profits outside of the United States. And the court decided this on a vote of 7-2, with Justice Thomas writing the majority, and a dissent by Justice Gorsuch, joined by Justice Breyer. So those were the 2 dissenters. And just before I get into the opinions, a little background about the case. So patent law is generally territorial. In general, a U.S. patent only protects against patent infringement in the United States. But there are some provisions that go beyond that. You can't create an infringing product in the United States for purposes of selling it abroad. And there are also some provisions that deal with creating the components for a patented invention, an invention that's covered by patents in the United States, creating those components in the United States, and then shipping them out of the United States for assembly into the finished infringing invention. And the particular provision that was at issue in the court's decision here was a section of the patent code called Section 271F2. And basically what it did is it said that if you supply a component that's specifically adapted for a use in a particular patented invention, and you supply that component from the United States to be used in that invention, something that would have infringed that invention were it done in the United States, then you're liable for infringement as if you had infringed that invention in the United States. So that's the type of infringement that's at issue in this case, and the damages provision that's being litigated is another provision called Section 284. And here's what it says. It says the court shall award the claimant damages adequate to compensate for the infringement, but in no event less than a reasonable royalty for the use made of the invention by the infringer. Now, so it's adequate to compensate for the infringement is the general language of what damages are available. And let me just give this briefly the facts of this specific infringement at issue, and then we can dig into the opinions. So the Western Gecko, the petitioner in this case, Western Gecko has patents on certain technology that's used to map the ocean floor, and this is used for oil and gas exploration. And Western Gecko didn't sell or license this technology. Instead, it was in the business of performing these ocean floor surveys. So it would be contracted by major petroleum companies to survey the ocean floor in particular areas. The defendant or the respondent in this case is a company called Ion Geophysical. And they created an imitation system, a system that basically was identical to the patented Western Gecko system. But the infringement at issue here was they shipped from the United States, they shipped components of this to be used in this system that would have been covered by the patent. They shipped them abroad to be assembled into the infringing system. They were found liable for infringement under that provision, that 271F2 provision, because of they shipped these components from the United States. So the question is Western Gecko entitled to, as part of its damages award, is entitled to damages for lost profits outside of the United States? And what they proved at trial was they proved 10 specific lost contracts. So this is contracts they would have obtained for this ocean floor mapping that they lost out to other companies that were using the infringing product that was infringing product, and they lost $93 million in lost profits due to these 10 lost contracts. So the question is, these contracts, these lost profits were for work that would have been performed outside of the United States, which is outside the normal territorial coverage of the U.S. patent. Are they entitled to that as damages for the infringement in this particular case? A core principle in this case is something known as the presumption against extraterritoriality, and that's the basic idea that laws are generally presumed to only apply within the United States unless Congress specifies otherwise. It's a presumption, and it can be overcome by evidence in the nature of the statutory provisions that it's intended to apply outside the United States. But that's the basic presumption. And so the question is, does that apply to this damages provision here, to say that this damages provision is really supposed to be for damages within the United States and not apply to those? So again, Justice Thomas wrote the majority. And what he does is he looks at this presumption against extraterritoriality, and he says that usually when courts are dealing with this presumption against extraterritoriality, there's two steps to it. First, they ask, has this presumption been rebutted? So does the text provide some sort of clear indication that this statute is supposed to apply extraterritorially? But then he says if it's not rebutted, so if we're assuming that this is a statute that's supposed to have domestic application, then you ask the question, well, is the application of the statute that's at issue here, is it actually domestic or foreign? Here he says the court doesn't need to answer that first question because the second question is determinative here. He says we can just ask the question of whether this is a domestic application of the statute. And he says in order to do that, we look at what is the statute's focus? What does it seek to regulate? And he says the provision at issue here, it has to be analyzed in the context of the entire statute. And the provision, this is section 284, the damages provision, it says that it's intended to provide damages adequate to compensate for the infringement. So the infringement is the focus of the statute. So he's asking, is the infringement that's at issue here, is that within the United States? Well, the provision, that 271F2 provision, is for infringement for supplying certain components in or from the United States. So he says the conduct that creates the infringement in this case, this is Ion Geophysical's supplying of components from the United States, that's domestic conduct. That's conduct that occurred within the United States. So he says that's a domestic application of this law. We don't have to worry about where the damages are coming from. It's the infringement, which is the focus of this law, happens in the United States, and everything else follows from there. And then he talks about the damages provision. He says damages aren't the statute's focus. They're just the means of remedying the targeted infringement. He says these overseas events, the overseas events underlying the damages award, are incidental to the infringement, and they don't have the primacy for purposes of the extraterritoriality determination. And he says that all he goes into the specific language of the damages provision, which talks about it being damages adequate to compensate for the infringement. And he says that concept of something being adequate to compensate for the infringement means it should place the patent owner in the position that the patent owner would have been in had the infringement never occurred in the first place, which can include lost profits. And so here, those lost profits, wherever they occurred, should be included in that calculation. Now, Justice Gorsuch dissented, again, joined by Justice Breyer. And he doesn't dispute the majority's analysis of the presumption against extraterritoriality, although he does, just briefly in passing, seem to kind of throw a little shade on the entire doctrine by referring to it as, quote, the judicially created presumption against the extraterritorial application of statutes. And given Gorsuch's judicial ideology, his very vocal expressions of support for things like textualism and originalism, that's kind of seems like somewhat of a disparaging label coming from him. But in any case, he doesn't dispute that. But he points specifically to the patent law's core purpose. And he says patent law protects only U.S. manufacture, use, and sale. To infringe a patent, you have to make, use, offer, or sell a patented invention within the United States. He says these lost profits are from foreign use, and that foreign use that led to the lost profits, those companies that overseas that were using this this invention that would have infringed had it been in the United States, well, that overseas use is not infringement. It doesn't violate the patent law, so it isn't a proper basis for a damages award. He says the foreign use of technology just doesn't interfere with the domestic monopoly that the patent law is supposed to create. And he says that even if this was an entirely U.S. manufactured product that was shipped for foreign use, those foreign uses are non-infringing and can't create that kind of liability. He says that the majority actually creates an anomaly here because it creates greater protection against the export of a component than it would for the entire product. And he also criticizes the majority's rule, saying that it allows bootstrapping, basically, of a domestic violation into potentially global profits. He says the majority doesn't explain why the damages adequate to compensate for the infringement should include damages that are harm from non-infringing uses. So that's the opinion and Gorsuch's response. And so let's move on to the next case the court decided on Friday. This is a case called Currier v. Virginia, and this is a case about double jeopardy. And specifically, it's about a doctrine related to double jeopardy, known as issue preclusion, or sometimes referred to as collateral estoppel. That's a kind of an older term for it. But this is the core idea of double jeopardy that people are probably familiar with is the idea that someone can't be tried multiple times for the same crime. So someone's tried once for a particular crime, whether they're convicted or acquitted, they can't be tried again for that same crime in another trial. Now, there's a separate concept known as issue preclusion, and this is the idea that if someone is acquitted of a particular crime and the jury, in acquitting that person, necessarily had to have rejected certain factual determinations in acquitting of that conduct, then those factual determinations should be preclusive on a future trial. So it should prevent the government from trying to relitigate that same point. That's the issue preclusion idea. So we're going to see how this comes into play in this case. Now, this was a 5-4 decision, and it broke down along the stereotypical conservative liberal lines. So you had a 5-justice majority written by Justice Gorsuch. You had a 4-justice dissent written by Justice Ginsburg. Now, there was also a concurrence by Justice Kennedy in part. Now, Justice Kennedy joined parts of Justice Gorsuch's majority, but he was not willing to go as far as the other justices in the majority. So I'll talk about that in a few minutes. Now, first, I want to briefly mention this issue preclusion idea. It's sometimes referred to as the Ashe doctrine, from a case called Ashe v. Swenson, and just very briefly give the facts of that case, just to explain this issue preclusion idea. Now, Ashe v. Swenson involved an armed robbery of 6 men at a private poker game. So it was a private poker game. 6 people were there. Robbers burst in. They robbed the 6 men. Now, Ashe was charged with the robberies, and he was charged as being one of the robbers who was there engaged in this robbery. He was tried for the robbery of 1 man. He was tried for the robbery of one of the 6 people there, but he was acquitted, and there were apparently identification questions. His defense was that he was misidentified and was not one of the people there. Now, there was no dispute that a robbery had occurred of all 6 of the men at the poker game. He was acquitted of when he was tried for the robbery of just one of those 6 men. Now, the government then tried to go forward and try him for the robbery of another of the 6 men at that same robbery. And this went all the way up to the Supreme Court, and the Supreme Court said that double jeopardy prevented a later trial, because the only issue at that first trial was whether he was actually there involved in the robbery, and the jury had acquitted him. The government couldn't go ahead and then try him again on a different charge of robbery arising out of that exact same circumstance, because that would be contradicting the jury's acquittal, because they would necessarily have to be finding something that's in conflict with the facts the jury had to have found to acquit him. So that's the case that kind of originated this issue preclusion doctrine, this idea that certain facts in an acquittal are preclusive on a future prosecution. So the facts in this particular case involved a theft from a theft of a safe from a home. And so there was a robbery. A safe was stolen, and this safe contained a significant amount of money, as well as a number of firearms. And the safe was eventually recovered where it had been dumped in a river, and the guns were still inside it, but the money was gone. Now, the Currier, the criminal defendant in this case, Currier was charged with multiple charges. He was charged with breaking and entering and grand larceny related to this burglary, but he was also charged with as being a felon in possession of a firearm. Now, he had prior convictions for breaking and entering and grand larceny. So that made him a felon who was not allowed to possess firearms. The only basis for this felon in possession charge was these firearms in the stolen safe. So the idea that is that when the burglars opened the safe to take all the money out, they were in possession of the firearms at the time that they were removing the money from the safe. So that was the only facts there. Now, under Virginia law, he was entitled to have the felon in possession charge severed from the other charges for purposes of trial. Now, the idea of this is, in order to convict someone of being a felon in possession of a firearm, you need to produce, the government needs to present evidence that the person is in fact a felon, that they have prior felony convictions. But the fact that someone has these prior felony convictions can be highly prejudicial. It can kind of cause a jury to be much more likely to want to convict someone, to believe that someone's guilty of whatever they're accused of. So in order to avoid the prejudice that comes from this felony being introduced on the other charges, Virginia allows a felon in possession charge to be severed. That means that he was entitled to have two separate trials, one on the theft charges, the breaking, entering, and the grand larceny, where the government would not be allowed to introduce evidence of his prior felony convictions, and a second trial on the firearm charge, where the government could introduce that evidence. Now, what happened was he was tried on the breaking and entering and grand larceny charges. He was acquitted on both those charges, and then the state moved ahead to try him again on the felon in possession charge. In that case, he was tried, he was convicted, and sentenced to prison for being a felon in possession. Now, he argued that this violates this issue preclusion idea, because if he was acquitted in the first trial, the jury necessarily found he wasn't involved in the theft of this safe, and that was the only facts involved in the felon in possession charge. That was the only basis for that charge, was his involvement in the burglary, and that's the time in which he was alleged to have come into possession of the firearms. So he argued that the same idea from the Ash case should prevent him from being retried. So that's the case as it comes here, and so let me move on from there to the opinions in this case. And again, Justice Gorsuch wrote the majority in this case, and he relies on some precedents of the court. And one of the key ones is a case called Jeffers v. United States from 1977. And this was a case where a defendant was tried for greater and lesser included offenses. So that there's a concept in criminal charges of greater and lesser included offenses, and the idea is sometimes there are multiple different levels of a particular crime, and you can think of a classic example being first and second degree murder. And where one of the crimes is considered to be included within the other, the elements you need to prove one of the crimes, it's just the greater crime is that plus some additional elements on top of that. So they're kind of two different levels of the same crime. And there's a longstanding precedent that double jeopardy applies when you have greater and lesser included offenses. If someone is acquitted or convicted on one of those two, on the greater or the lesser, they can't later be tried on the other. Now, in this Jeffers case, the defendant, Jeffers, sought separate trials of greater and lesser included offenses. So for strategic reasons, he wanted those to be tried separately, and they were. And he was convicted on the lesser offense, and then he sought to block the trial on the greater offense using this double jeopardy concept. The court said, no, the Supreme Court ruled that there was no double jeopardy because he consented to splitting this into two trials. Now, normally he would have the conviction on the first one. Even though it was a conviction, it would have prevented the government from then trying to try him on the greater charge. But his consent to splitting it meant that double jeopardy didn't apply. Now, Gorsuch says that this case here, it follows from that. He says here we're not dealing about the same crime, which is the classic double jeopardy of the greater and lesser included offenses, but we're dealing with this issue preclusion idea. And he says that there's no real difference for double jeopardy purposes between whether the original trial was a conviction, as in the Jeffers case, or an acquittal, as in Currier's case here. And he points to some other precedents, saying, for example, when someone moves for a mistrial, when a defendant says that the judge must declare a mistrial because of something that happened during the course of the trial, that basically allows the government to try someone. It acts as if it's consent to a retrial, and double jeopardy doesn't apply. And he says here, Currier was definitely put to a difficult choice. If he had elected to have everything tried together in a single trial, which Virginia could have constitutionally done, it might have disadvantaged him because that his prior convictions could have been introduced, and that might have really harmed him. But that's not unconstitutional, and those could have been tried together. The judge would have given jury instructions, instructing the jury not to use the prior convictions for certain purposes, but it would have been perfectly constitutional to do so. So Currier was put to a choice. He had an option of trying these separately or letting them be tried together, but it wasn't an unconstitutional choice. He had difficult choices, but that was his choice to make, and by choosing to try them separately, he effectively consented to the second trial, and did not cannot claim the protections of double jeopardy. Now, Gorsuch's opinion goes on, but this portion of the opinion is not joined by Justice Kennedy. I'll come back to Justice Kennedy in a few minutes. Justice Gorsuch goes on to examine this whole issue preclusion idea in more detail, and he basically casts doubt on the entire concept. He says that the language of the double jeopardy clause, it protects someone from, quote, being, quote, twice put in jeopardy for the same offense, and he compares this, for example, to the language of the Seventh Amendment, which protects the right to a jury trial, and which specifically says, no fact tried by a jury shall be otherwise re-examined in any court of the United States, etc. And he says there, look, on the Seventh Amendment, where they're protecting this jury right, it's very specific, it's very explicit about dealing with specific facts that a jury has decided. But when we're talking about double jeopardy, it's just talking about the same offense. And so he points to that kind of textual difference. And then he points to history, and he goes through English common law history and early U.S. history. And his argument is just that this issue preclusion idea just was not protected, even for offenses with overlapping facts. There's no historical basis for this issue preclusion idea. So he kind of is rejecting or casting doubt on this entire idea of issue preclusion that comes from this Ash case. And he also points to some practical effects. He says, if we take this idea seriously, would it allow the government to do the same thing? Would it allow the government to use this issue preclusion idea in an offensive manner against a defendant? For example, if a defendant was convicted in a first trial and certain facts were established, could the government go into a second criminal trial on a different but overlapping charge and argue that the jury could not redecide those facts that had been established in the government's favor in the first case? And Gorsuch also points to the fact that, as I mentioned before, Virginia did not have to split this into two separate trials. They didn't have to allow him to sever this. But he notes that some states are much more generous than others about severing charges. Having multiple trials has increased expenses. There's a lot of inconvenience. Witnesses have to come and testify multiple times. But nevertheless, some states allow it more than they have to for constitutional reasons. And Gorsuch says basically a broad application of this issue preclusion idea would likely have the effect of discouraging states from allowing these kind of severances. It would create a more of a cost to them of doing so, and make them less inclined to allow these kinds of severances. So that's Justice Gorsuch's majority opinion. Now, Justice Kennedy concurred, and what he says is basically, he says this entire case is resolved on the issue of consent. So he agreed, he joined the beginning of Justice Gorsuch's opinion and said the fact that Currier consented to trying these charges separately answers the question, and he doesn't think it was necessary for Gorsuch to go on to this broader question of the issue preclusion doctrine generally. And he says he expresses no view, basically. He expresses no view in this opinion on that broader question. He just wanted to resolve it solely on the consent issue. So that brings me to the dissent. Now, Justice Ginsburg wrote the dissent for 4 justices. And what she does is she says that the double jeopardy protection really serves 2 separate purposes. One of those 2 purposes is avoiding multiple trials for the same offense. And this applies, this is the classic double jeopardy, you can't be tried twice for the same offense. And this applies regardless of whether the first trial results in a conviction or an acquittal. It also includes greater and lesser included offenses, but it's a protection that just says the government just can't keep retrying someone for the same offense. It doesn't matter if they're convicted the first time or acquitted the first time, one try, and that's it. And that's the end. Now, but she says there's a separate principle that the double jeopardy clause is also supposed to serve, and that's the finality of acquittals. In our legal system, in our criminal justice system, acquittals carry an enormous amount of weight. Now, normally, like if someone is acquitted in front of a jury trial, the government can't appeal an acquittal, even if there may have been errors in the trial or errors in jury instructions that went to the disadvantage of the government. The government is precluded normally from can't appeal an acquittal. Acquittals have this enormous amount of respect in our legal system, and so she says that supports this rule from the Ash v. Swenson case, this issue preclusion principle, and that's a separate and distinct principle from the multiple trials protection. And what she says is that there's case law, the Supreme Court's case law clearly establishes that this issue preclusion concept applies regardless of whether there's any prosecutorial overreach or misconduct. So even when trials are severed for purposes that benefit the defendant, this issue preclusion idea still applies. So the fact that this severance here went to Currier's was for Currier's benefit because it would not allow his prior convictions to be introduced in the breaking and entering and larceny charges. That doesn't stop this principle from applying. And she says that normally constitutional rights, in order to there's a high burden to show that someone has waived a constitutional right, and here she says that burden is not met here. She says that there was no express waiver of this issue preclusion idea. He agreed to have 2 separate trials of these different charges, but never agreed that a acquittal in the first should have no impact on the second. And Ginsburg says that waiving a constitutional right by conduct, so for example, just by his consent to do that, that was only available in a narrow set of circumstances, when a defendant acts in some way that's completely inconsistent with exercising the right at issue. But here, there's nothing inconsistent about agreeing to 2 trials and then arguing for this issue preclusion, because she says issue preclusion doesn't bar a retrial. It only bars retrial on a particular theory of the crime. So, for example, going back to the Ash case, the one about the robbery of 6 men at a poker game, the idea of issue preclusion wouldn't have prevented a retrial of Ash on a theory, for example, that Ash drove the getaway car for the robbery and was guilty of it in that sense, because that wouldn't contradict the facts that the jury necessarily found in the first trial. So it doesn't prevent the retrial, just prevents a particular theory of the retrial, a theory that has been necessarily dismissed by the jury. So here in Currier, again, it wouldn't have prevented the state from retrying Currier on a theory, for example, that Currier met up with the robbers after the robbery and was involved in emptying out the safe, because that wasn't the theory that the jury dismissed in the first trial. So she says there's nothing inconsistent about agreeing to separate trials and then later wanting to have this issue preclusion idea apply. And she says none of the cases that the majority relies on involved a prior acquittal. They all involved cases where the person was convicted in the first trial, or before when there had been no verdict, when a trial was ended or dismissed, or there's a mistrial for some reason before a verdict was reached in the first trial. And so she says the idea of this, the finality of acquittals, the majority's cases don't support the lack of respect for that concept. Now, Ginsburg explicitly chooses not to engage the plurality. That's Gorsuch when he's not speaking for Justice Kennedy, when he's just writing for four justices. She explicitly says she's not engaging in the historical challenge to the entire doctrine of issue preclusion. So the Gorsuch's suggestion that the whole idea, starting with the Ashe case, isn't sound and isn't there. Ginsburg just says she's not going to address that. So that's it for Currier. So let's move on to two more cases. Now these get a little more involved, a little bit more complicated, but I'll try and run through each of them. Now the first case I'm going to talk about is a case called Ortiz v. United States. Now this case was originally, it was actually 3 consolidated cases at the Supreme Court. The other 2 cases, along with Ortiz, were called Dalmazzi v. United States and Cox v. United States. But I'll explain a little bit later, those other 2 cases, the court split the cases back apart for purposes of decision here, and it only issued an opinion in Ortiz and ended up dismissing the other 2 cases. And I'll explain that when I get to the end. I'll explain the situation there. But these are cases challenging the legality of certain judges that were serving on the criminal courts of appeal, or Court of Criminal Appeals, for 2 branches of the armed services, the Army Court of Criminal Appeals and the Air Force Court of Criminal Appeals. And there was an argument that the service of certain judges on those courts was unlawful. Let me just kind of give some basic background here. And the defendants in each of these 3 cases, so Ortiz and the defendants in the other 2 consolidated cases, were all service members who had been convicted of crimes in military courts. And now here, there's a couple acronyms involved in this case, and I'll just try and explain them briefly. There's the CCAs, which are the Courts of Criminal Appeals, which I mentioned, and these are courts within the military that hear appeals from courts martial. So if someone's convicted in a court martial, they can appeal to the Court of Criminal Appeals for their particular branch of the military. And then those cases from the CCAs, the Courts of Criminal Appeals, can be further appealed to the Court of Appeals for the Armed Forces, or the CAAF is the acronym for that. And that's the highest appeals court for the military system. It sits above the CCAs. And then cases at the CAAF, that Court of Appeals for the Armed Forces, those can be appealed up to the Supreme Court through the court's normal, the certiorari process, where you petition the Supreme Court and ask the court to take those cases. That's significant, and that's something I'll be coming back to in a minute. So we have the CCAs, which is the Court of Appeal that reviews a court martial, and then the CAAF, the Court of Appeals for the Armed Forces, at the top of the military system. Now, the other separate court that's involved in this case is referred to as the CMCR, which is the Court of Military Commission Review. And this is a court that reviews, sits in appeal, hears appeals of military commissions. So these are, for example, the commissions in Guantanamo that adjudicate the status of enemy combatants from Afghanistan, for example, held in Guantanamo. And so the CMCR is the court that hears appeals from those military commissions. Now, here's what the case is basically about. There's a federal law that dates back to 1870 that disqualifies active duty military personnel from simultaneously serving in a civil office. This is referred to as the dual office holding ban. Now, that law, it's been in place since 1870. The current law has certain exceptions, but it among other things, it prohibits military personnel from holding offices that require a presidential appointment and Senate confirmation. Now, part of the purpose of this was there's concern after the Civil War. There were so many prominent people serving in military as military officers, and there's a concern that the government, the federal government, would become fall under the sway of the military by having high office holders in the federal government simultaneously serving in military positions, and so this dual office holding prohibition went into place. Now, the issue here is that in each of the cases that was at issue here, one of the judges sitting on the CCA, the Court of Criminal Appeals for a military branch, one of the judges sitting on each of those courts was appointed to the CMCR, the Commission for the Court of Military Commission Review. Now, the Court of Military Commission Review, the appeals from that go to the civilian courts. The president can appoint either civilians or military personnel to the CMCR. So the argument is this CMCR, the judges on that's a civil office, and so this civil office, this should fall under this dual office holding ban, that someone who's a military officer, like these judges in the CCA, should be barred from serving on the CMCR. So this challenge was brought, arguing that was unlawful, and also the argument was made that there was traditionally the remedy for this type of dual office holding. If someone was a military officer and then took on, it was appointed to an inconsistent civil office, the remedy was that they would be immediately terminated from their military service. So the idea was, upon being seated on the CMCR, they by law they would no longer be able to be a member of the military, and therefore their service on the CCA would have had to have ceased at that point. So that's the basic idea of the challenge. There was a separate, along with that, the statutory argument about this dual office holding ban, there was also a challenge under the appointments clause of the Constitution. And that is, the appointments clause is a clause of the Constitution that indicates how federal officers can be appointed. And the Constitution distinguishes between principal and inferior officers. Principal officers have to be appointed by the president and confirmed by the Senate, but inferior officers can be appointed in other manners. And the argument here was that the CCA judges are inferior officers, where the CMCR judges are allegedly principal offices. And the argument was made that there's an inconsistency with someone holding a principal and inferior office at the same time, and that violates the appointments clause. So that's the basic arguments here. But there was one more kind of big monkey wrench in this case, which was that one of an argument was made by an amicus, so that's someone who's not a party to the case. And in this case, it was a law professor named Aditya Bamzai, who made the argument that, in fact, the Supreme Court had no jurisdiction to hear appeals from the CAAF. Now, the court has heard appeals from the CAAF a number of times over the years, but the argument was the Supreme Court actually has no jurisdiction over that. And the reason was the Supreme Court has certain narrow categories of what is known as original jurisdiction. That means cases that can be brought directly in the Supreme Court, and that's a very narrow category. The Supreme Court, the most common type of those are interstate disputes, when one state directly sues another state. But it's very narrow. Now, most of the cases the court hears are in its appellate jurisdiction, meaning it's hearing things as a court of appeal, hearing an appeal from another court, and the argument here is the CAAF is not a real court. It's not a court. It's not part of the judicial branch of the federal government. It's actually part of the executive branch as a part of the military, and therefore this is not actually an appeal. Really, going from the CAAF to the Supreme Court would be a brand new judicial action, because there's no existing judicial action to bring in to the Supreme Court. So the argument here, so the court chose to address that argument, and actually had the amicus, the law professor, argue at oral argument on that point. And so with that background in place, I'm going to dive into the opinions. Now, Justice Kagan, wrote the majority opinion, and that was an opinion for 7 justices. And she starts with that jurisdictional issue, the one I just mentioned, about whether the Supreme Court can hear an appeal from the CAAF. And what she argues is, she says that the key language is other cases. The appellate jurisdiction goes to other cases in certain categories, and she says that under a common sense, ordinary understanding of what is a case that can be appealed to the Supreme Court, the military proceedings involved here involve a case in a court. She says that the military system is judicial in character. It functions analogously to the federal judicial system, has a similar structure and jurisdiction. It has a very well-established constitutional pedigree. The courts martial actually predate the Constitution. And despite its placement within the military, it's judicial in character. And even when it's serving a military purpose and imposing discipline on the military personnel, it's done in a judicial way through judicial processes and procedures. And then she points, in addition to this, to other courts that are outside of the judicial branch of the federal government. Now, in legal talk, the phrase Article 3 is used just in general to refer to the judicial branch of the federal government, because in the Constitution, Article 3 is the article of the Constitution that establishes the federal judiciary. Article 1 establishes the legislature. Article 2 is the executive branch of the presidency, and Article 3 is the judiciary. So Article 3 courts refer to courts that are part of the federal judicial branch. But the Supreme Court can hear, and it's well established, can hear appeals from courts that are outside of Article 3. And this includes state courts, for example. But it also includes, within the federal government, but outside of the judicial branch, federal territorial courts. So this is, for example, this would include territories like the U.S. Virgin Islands, where they have their own court system, but it's not a state of the United States. It's federally governed. But it has its own court system that's been established there by Congress. That also involves the local court system in the District of Columbia. So the District of Columbia is controlled indirectly by the federal government. It was established by the federal government, and the government of the District of Columbia was established by Congress. But it has its own court system that functions just much like a state court system would function. And Congress has authority to, the Supreme Court has authority to hear appeals directly from the DC, the local courts there. And so Justice Kagan, kind of by analogy to these, says that the military is basically the same way. And she also distinguishes it. She says, although these military courts, the courts martial, are within the executive branch, she distinguishes this from other actions by executive officials which are not reviewable in the Supreme Court directly, don't fall within the Supreme Court's appellate jurisdiction. Just by referring to this judicial character of them, the fact that they're courts issuing judicial decisions, and that's what makes them reviewable. But she leaves open the question of whether there might be appellate authority over other executive branch adjudicating bodies. She kind of leaves that question open and doesn't address it. But again, so with that jurisdictional question out of the way, she goes on to this dual office holding issue. And what she does is she talks about the statutory bar to dual office holding. So the provision at issue is referred to as Section 973B2A, and that prohibits active duty military officers from holding or exercising the functions of certain civil offices. But there's an important exception. It says, except as otherwise authorized by law. And what she says is another provision of law does otherwise authorize this. And what it is there's a provision relating to the CMCR. This is the Court of Military Commission Review. There's a provision of that explicitly says that the Secretary of Defense may assign officers serving on a CCA, that's the Military Court of Criminal Appeals. So the Secretary of Defense may assign an officer serving on that to be a judge on the CMCR. And so Justice Kagan says that right there is the authorization. That otherwise authorizes this military officer to serve on in this civil office. Now, the argument from the defendant Ortiz in this case was that in these particular cases, the judges at issue were assigned to the CMCR by the Secretary of Defense, but a decision was made later that to have the president afterwards appoint them also to the CMCR. The other way someone can get on the CMCR by presidential appointment and confirmation by the Senate. And the argument is that that provision, a separate provision that allows for the president to appoint and have the Senate confirm someone to that, doesn't expressly reference military officers. Unlike the Secretary of Defense provision, which was specifically about military officers, the presidential appointment section doesn't refer to military officers and allows the president to appoint civilians to those positions also. And so the argument was that doesn't fit within the exception to the dual office holding ban. Now, Justice Kagan says this is irrelevant because here the president's appointment didn't undo the secretary's appointment. The Secretary of Defense had appointed them, the president appointed them, and those two things were not incompatible. It was just a double appointment, and it was authorized by the first of those when the secretary appointed. So that's irrelevant. And Justice Kagan says because of that, there's no need to address the question of whether had these judges only been appointed by the president under the provision for presidential appointment, whether that also would have satisfied the otherwise authorized provision. No need to get into that here because the Secretary of Defense's appointment clearly meets the standard. And she also says there's no need to decide, because it actually is an open issue, whether the CMCR judges, whether that is in fact a civil office subject to this dual office holding ban in the first place. And no need to deal with the remedial issue, that is, whether if there had been a conflict under the dual office holding provision, whether that would require termination of military service. No need to get into any of that because, in fact, it was authorized. So this brings me to the constitutional issue, the Appointments Clause issue. And this is the alleged conflict between someone simultaneously holding an inferior office and a principal office. Justice Kagan quickly disposes of this and basically just says there's no support for this incompatibility argument. She says that there's just no cases or no authority that says that this conflict is unconstitutional. And then she says even if there were something to this, in this particular case, there's no plausible story about why there's some conflict between here. There's no reason why there'd be some sort of undue influence by having someone who is a principal officer on the CMCR also serve as an inferior officer on the CCA. She says, here's a quote, "The two courts do not have any overlapping jurisdiction. They're parts of separate judicial systems adjudicating different kinds of charges against different kinds of defendants." So she dismisses that argument. So that resolves the case for Justice Kagan. So that moves me on to Justice Thomas, who had his own concurrence. Now, he says he agrees entirely with the majority, but he goes on to, he wants to discuss in more detail the issue of Article 3, that's the judicial branch under the Constitution. And what he argues is he believes that the court cannot exercise appellate jurisdiction, so the Supreme Court can't exercise appellate jurisdiction unless it's reviewing an exercise of judicial power. Now, this judicial the appeals don't have to come from a specific type of tribunal. They don't have to come from an Article 3 court. So they don't have to be part of this federal judicial power from the Article 3 court, but they do have to be an exercise of judicial power. Now, this explains why the Supreme Court can hear appeals from state courts, because they are exercising the state's own judicial power, not the federal judicial power. But he argues that this explains some of the exceptions here. He says here, Congress, just like Congress could establish in the territories, it could establish these judicial functions, judicial power within those territories because of its enormous power over to create functioning governments in those territories. In the military, Congress has a vast control over the military that allows it to create a separate military judicial power. So the military courts are exercising an actual judicial power through the Congress's vast authority over the military, but they're not, even though they're not within Article 3 for this historical reason. So they're not part of the judicial power that's assigned to the federal judiciary. It's a separate judicial power that comes from Congress's vast authority to create rules for governing the armed forces. And so that's kind of his explanation. Now he goes on to say that whether something is or is not a judicial power that's being exercised, he says it's a functionalist examination. So whether something is judicial power depends on what is being done. And he says here, these are courts. They're courts acting like courts. So this is judicial power, regardless of where that exercise is coming from. And then from there, he goes to the administrative agencies. Now and he points to the agencies operating within the executive branch and adjudications that happen within those agencies. And what he says here, and this is kind of a radical position that he's taking out here, he says those administrative agencies, even though they're fully within the executive branch, they are also exercising judicial power by functioning in this court-like manner and adjudicating cases. However, he says the difference between those and the military is that those are unconstitutional exercises of judicial power, where the military, for these historical reasons and Congress's broad power over the military, are constitutional. So he's kind of taking this opportunity in this particular case to stake out a very strong position against the constitutionality of administrative adjudication. It's kind of something that's not an issue in this case at all. It's a totally separate issue, but he is using this opportunity to kind of opine on that in discussing the relationship between judicial power in general and the federal, the Article 3 judicial power. So that brings me to the dissent, and here the dissent is written by Justice Alito, joined by Justice Gorsuch, and this opinion is a very it's about a formalist division of power between the branches under the federal Constitution. He says that basically the federal courts exercise the Article 3 judicial power, and he says the state courts exercise the state judicial power. Now, the territorial courts, those are legitimate because they're exercising the judicial power of those territorial governments. And by creating an entirely new government, Congress has the power to create governments for these territories. And those territories come with the full range of legislative, judicial power, et cetera. So those territorial courts exercise judicial power by virtue of being part of a separate territorial government. But he says executive branch adjudication can never be judicial power. Congress cannot place judicial power within the executive branch. And from there, he says that governs the military in this case. The military is clearly part of the executive branch. It's within the executive chain of command. It's always been considered part of the executive branch. It reports directly to the president. And as such, it cannot be exercising judicial power. He points to the requirements. What does it mean for something to be under the Article 3 judicial power? The key requirements of that are that the judges, in order for someone to be a Article 3 judge, a judge that hears exercises the federal judicial power, has to be a judge with life tenure and salary protection. And that's the status of all the federal judges, from the district judges all the way up to the Supreme Court. But he points here to the Court of Appeals for the Armed Forces. He says the judges there serve a fixed 15-year term. They're not they don't have this life tenure that Article 3 judges have. And he says in this case, there wasn't an Article 3 case. There wasn't an exercise of Article 3 judicial power until the cert petition, until it came up to the Supreme Court. And so he says this can't be an appeal. And he accuses the majority here of ignoring what he says are 200 years of history here. And he points to other courts that had been within other branches of the government, within and one is the Court of Claims, and he's which is a court that hears claims against the federal government, claims for money from the federal government. And the Supreme Court had held early in, when the Court of Claims was not staffed by Article 3 judges, that the Supreme Court could not exercise appellate jurisdiction over that court. And later, that court also was subject to review by the Secretary of the Treasury. So it was under the executive branch. The court said the court could not exercise appellate jurisdiction. Later, Congress amended the the statutes to remove that kind of review and to place it into Article 3 completely. And then at that point, the court said that that was now reviewable on appeal to the Supreme Court. There's other precedents that Alito points to in the habeas corpus area and in military tribunals, where appeals to the Supreme Court were rejected because they were not within the exercise of Article 3 judicial power. So he says, under this historical understanding, the Court of Appeals for the Armed Forces should be outside of that. Now, he goes on to talk about the D.C., the District of Columbia, and territorial courts. And he says here that there's long-standing precedent that the Article 3's grant of judicial authority to the definition of judicial authority basically excluded territorial governments, because that power to create a whole new government is kind of a special authority that Congress has. But he rejects any analogy from that to the military. He says the military, unlike these territorial governments, the military is not a government unto itself. It's firmly situated within the executive branch. And he points to some other things. For example, the courts martial are exempted from other constitutional provisions that govern the judiciary. For example, the right to a jury trial. And in fact, until 1920, the president and certain commanding officers could actually impose harsher punishments than had been imposed in the courts martial. They could step in and do that. So he's saying that it's clear that this has long been considered part of the executive branch, part of the power to try and punish military offenses, which is entirely independent of the Article 3 judiciary and not part of the federal judicial power. He argues that there's really no principal distinction between the Court of Appeals for the Armed Forces and administrative adjudication, and the fact that you can't appeal administrative adjudications directly to the Supreme Court. Those have to be appealed to lower courts. The same thing should apply to the Court of Appeals for the Armed Forces. So that's the dissent in this case. Now I want to talk briefly about the consolidated cases. I mentioned that there were originally 3 cases together: Ortiz along with Dalmazzi and Cox. Now, a footnote in the Ortiz opinion just says very briefly, it refers to those 2 cases and says, quote, "Those cases raise issues of statutory jurisdiction that our disposition today makes it unnecessary to resolve." And then the court issued separate orders dismissing each of those 2 cases as improvidently granted. So just basically getting rid of those cases, saying it never should have taken those cases, and sending them away. Now, what happened in those cases is that in each of those 2 cases, the Court of Appeals for the Armed Forces had originally agreed to hear those cases on appeal from the CCA. But it turned out in each of those cases, the commission for the judge who had been appointed to sit on the CMCR in each of those cases, the commission for that office, the commission to sit on the CMCR, had not been signed at the time when each of those judges had ruled on the case at the CCA. So the Court of Appeals for the Armed Forces said, because of that timing issue, because at the time when they ruled in the CCA case, they weren't yet on the CMCR, that this issue just it was moot. It didn't this conflict didn't come up. So the CAAF, because of that, it vacated its grant of these cases from the CCA. So it changed its mind, decided not to hear the appeal from the CCA, denied the petitions, and said it refused to hear those. So again, the CAAF, the Court of Appeals for the Armed Forces, has a discretionary review of lower military cases. It doesn't have to take cases. It's like the Supreme Court. It picks and chooses which cases it wants to hear. So it ends up making the discretionary determination after the fact. It changed its mind, said I'm not going to grant this case, and denied the petitions. Now, the Supreme Court statutory jurisdiction to hear cases from the CAAF, it can hear decisions of the CAAF, but the argument here is there's no decision of the CAAF. There's just that unreviewable discretionary determination of whether to hear a case in the first place. So that's not reviewable by the Supreme Court. So that was one of the issues in these cases that the court would have had to deal with, was whether the fact that the CAAF denied the petitions after the fact and decided not to hear these cases, whether that prevented the Supreme Court from getting into it. Well, the Supreme Court said, since we decided in Ortiz that there's no problem here anyway, there's no issue, it doesn't make any sense to try and decide this other question of whether we can even review these cases. We're just going to throw them out. And that's what the court did. So that gets me to the end of Ortiz and brings me to the fourth and final case that was handed down on Friday. And that case is Carpenter v. United States. And this is a case about the government's access to cell site location information, abbreviated sometimes as CSLI in the opinions here. And what that is that's information about which cell tower a particular phone is connected to at any given point in time, and the carriers, the cell carriers, they have historical information on this, which can indicate for any particular phone what tower that phone was in communication with at any point in time, going back for presumably the length of the contract with that carrier. And the issue in this case was whether the government can obtain that information without a warrant. And this split 5-4. The majority was written by Justice Roberts, joined by the 4 more liberal justices on the court. And then the 4 other conservative justices were in dissent, and each of them wrote a separate dissent here. Justice Kennedy wrote the principal dissent, joined by Justice Thomas and Alito. Justice Thomas wrote his own dissent. Justice Alito wrote a dissent, joined by Justice Thomas. And then Justice Gorsuch wrote his own final dissent. And Justice Gorsuch, as we'll see, his is quite a bit different. And it's been characterized by many commenters as practically a concurrence in disguise rather than really a dissent. And we'll talk about that when we get to it. But first, the basic facts of this case. The criminal defendant in this case was Timothy Carpenter. And he was alleged to be involved in the armed robberies of a number of retail stores, including actually some cell phone stores. And there were robberies, about 9 robberies, and Carpenter was alleged to be the ringleader of these robberies. Some of the people who were picked up by the police for their involvement in these robberies named Carpenter as the brains behind the operation. Now, in order to help prove their case, the government obtained from Carpenter's cell carrier, he obtained location data, and at trial showed the jury that his cell phone was connected to a tower in close proximity to several of the different robbery sites at the time of the robberies, and he was not normally in those vicinities. So it's saying basically it's quite a coincidence that he just happens to be at these widely these locations which were in widely dispersed spots in 2 different states. He happened to be there at multiple places at the time when the robberies were occurring. So that was the evidence they used. Now, he challenged this as a violation of his Fourth Amendment rights. Now, how did the government get this data? Well, under a federal statute called the Stored Communications Act, the government was able to go to the cell carriers and actually go to a magistrate judge and get an order ordering the carriers to turn over that information. So under the Stored Communications Act, a magistrate ruled that the government could access this information, and the cell carriers turn this over. And Carpenter argued this violates the Fourth Amendment. He says the government needs a warrant in order to obtain this information. So let me run through this. There's 5 separate opinions in this case because each of the dissenters wrote a separate dissent. So this ended up being very lengthy. All the opinions together ran to 119 pages. I'll try and run relatively quickly through it all just to get us through this. But Justice Roberts again wrote the majority, and he says that basically the court's rule in this area. The court's rule is to ask whether there's a reasonable expectation of privacy over whatever intrusion the government is involved in. And he says that there's a couple purposes here. It's supposed to secure privacy against arbitrary government power. And it's also supposed to place obstacles in the way of a kind of a total police surveillance of the public. He says this is a historically informed test, but it has to be adapted to the increased technological surveillance that's possible with modern technology. And he points to two lines of cases that he says are relevant here. And one is a set of cases that he says stand for the idea that location information, that there's a strong privacy information, privacy interest in location information. And the key case here is from a few years back called United States v. Jones, and involved the government placing a GPS tracker on someone's car to follow where that car traveled for an extended period of time. And the court struck that down, saying that that violated the Fourth Amendment. The other line of cases is something known as the third-party doctrine. And the third-party doctrine is the general idea behind this doctrine is when someone provides information to a third party, then they lose the expectation of privacy in that data, and they don't have it basically removes it from the protection of the Fourth Amendment because they have no reasonable expectation of privacy. And the key cases in that was a case called United States v. Miller, and that involved a subpoena for bank records in order for the government to try and prove tax evasion. The court in that case said there was just no expectation of privacy in information that had been voluntarily shared with the bank, so that financial information could be seized just through a simple subpoena. And the second case is called Smith v. Maryland. And in this case, the government used something called a pen register, which is just a device that intercepts numbers that are dialed on a telephone, so to determine who somebody is calling. It's not a wiretap where they can actually listen in on the conversation, but it indicates who someone is calling. And the court said, again, there's no expectation of privacy in the numbers because the number you're dialing is necessarily shared with the phone company in order to complete that call. And so that's information you've voluntarily given to another party, so the government can go and get that information. Now, Justice Roberts says, looking at that third-party doctrine and the Smith and Miller cases, he says, we decline to extend Smith and Miller to cover these novel circumstances. And here, the novel circumstances he's referring to are the ubiquity of cell phones and this location data that can cover all of a person's movements over enormous periods of time. And so he says under these circumstances, this third-party doctrine, the Smith and Miller idea, that when information is in the possession of a third party, there's no expectation of privacy. It just doesn't apply in this setting. He notes the kind of all-encompassing record of a phone holder's whereabouts that are available in these, and he says, here's a quote. He says, quote, "The time-stamped data provides an intimate window into a person's life, revealing not only his particular movements, but through them his familial, political, professional, religious, and sexual associations." And he also points to the ease of obtaining these from cell carriers. He says just with a push of a button, this information can be downloaded, and also the fact that this is a retrospective capability. So the government doesn't have to decide up front that it wants to surveil someone. They can decide after the fact and collect years potentially worth of data on every place that someone went carrying their cell phone. So he says that in this context, that obtaining this information invades the reasonable expectation of privacy that someone has in their own physical movements. And he talks about the third-party doctrine cases and says basically the data in question here is much more revealing than the information in previous third-party doctrine cases. And he also says, referring to those Miller and Smith cases, he says those cases weren't just about sharing the information with a third party. They also involved consideration of the specific privacy interest in the types of information being sought. And so he says, really, it's kind of a balancing situation. And here, the privacy interests are much stronger. And so that changes the calculus here. And he also says here, it's not really a voluntary disclosure because cell phones for many people are indispensable. And the location data, the transmittal of the location data to the cell provider happens automatically without any user interaction. So we can't really call this, he says, a voluntary disclosure to the third-party cell phone carrier. Now, he says that this is narrow in scope, and he specifically carves out certain things he's not ruling on. He says that the court here, the smallest period of time that was sought from one of the cell phone carriers was a 7-day period of time, and he says we're not ruling on whether a shorter period of time would be also protected. He also says that he's not ruling on real-time cell site location information. So if they're trying to find out where someone is in real time, is that governed by the same requirement of a warrant. He's leaving that open, and also he's not ruling on what are referred to as tower dumps. Now, a tower dump is, instead of saying, here's one phone number, I want to track where this was at all times, you say, here's one tower, I want to track every phone that connected to it within some period of time. So it's kind of coming at it from the opposite direction. And he doesn't rule on that. He kind of leaves those open, doesn't give any indication of which way they would go. So anyway, moving on, having found that there is a reasonable expectation of privacy, he says this is a search under the Fourth Amendment. So is a warrant required? The Fourth Amendment standard is that searches must be reasonable. It protects from unreasonable searches, but generally warrantless searches are considered to be unreasonable unless they fall in a specific exception. And here he says that the standard here, the Stored Communications Act, which was the standard applied here, it required only reasonable grounds for believing records were relevant and material to an ongoing investigation. And he says that this is well below the normal probable cause standard that applies under the Fourth Amendment, which generally requires some sort of individualized suspicion at least. And so he says that here that's not reasonable, and a warrant should be required. He also holds open that there may be what are known as exigent circumstances that still apply. So exigent circumstances are an exception to the normal warrant requirement under the Fourth Amendment. And this covers things like hot pursuit, for example, or if there's a risk of imminent harm. So things like that, he says they may still apply. So there might be exceptions to this in particular cases where a warrant isn't required if the law enforcement has to act fast because of some special circumstances. So that's the majority here. So now let's move on and work through each of the dissents in this case. We'll start with Justice Kennedy's dissent. Now, Justice Kennedy says that there's two general doctrines that govern this case. He says this is governed by the third-party doctrine and by the business records, the normal treatment under the Fourth Amendment is business records. And he says basically here, he says customers like petitioner, this is a quote, customers like petitioner do not own, possess, control, or use the records, and for that reason, they have no reasonable expectation that they cannot be disclosed. And he also says that some of the distinctions the majority draws, the distinction between this cell site location information and, for example, phone numbers dialed or credit card records, is an arbitrary distinction that just that doesn't make sense. And what he says here is the Miller and Smith cases, the third-party doctrine cases, they dictate the answer in this case. He says individuals, and this is a quote, individuals lack any protected Fourth Amendment interests in records that are possessed, owned, and controlled only by a third party. And he says that there's a couple important reasons for this third-party doctrine. He says, first, it places some necessary limits on the ability of defendants to claim a Fourth Amendment interest in property which they lack a quote requisite connection to. So he says the court has to draw a line somewhere, and this third-party doctrine is a place to draw that line. And he points to some factors of it. For example, the fact that a business can use this information for its own purposes. And so the customer doesn't have this strong interest in how that information or data is used. And also, he points to this. The second factor is the use of compulsory process to obtain records. Now, compulsory process means certain legal tools that allow someone to demand records from another party, and this is generally we're talking about subpoenas. So subpoenas are used in a wide variety of situations, including civil litigation, grand jury investigations, and various other contexts like national security investigations. And they allow the government to obtain all manner of records from businesses, from individuals, by requesting that information. And he says there's a long-standing distinction between compulsory process, so subpoenas, and searches under the Fourth Amendment. A subpoena is less intrusive than a search, than the execution of a warrant, because subpoenas allow the party who's being collected from to do the collection themselves. The government demands that you turn certain things over, but they're not actually physically invading and rifling through all of your papers and documents. And they also give an opportunity for the party who's subject to the subpoena to make objections before they have to execute it, rather than a search warrant where you can only complain after the fact, after everything's already been rifled through. And Kennedy says these are just very different situations, and a subpoena is governed by a reasonableness standard, not by this probable cause that applies to searches under the Fourth Amendment. And subpoenas are regularly used for business records that reveal all sorts of private information for credit card purchases, hotel records, employment files, things like that. They may have very revealing private information, but subpoenas are used for those things all the time. And he says there's just no merit to carve out a special exception for this cell site location information. He says the Stored Communications Act, unlike many mere subpoenas, actually requires approval by a magistrate. So there's actually more protection than many subpoenas. And he criticizes the majority's use of the Miller and Smith third-party doctrine. He says that they make this doctrine unprincipled and unworkable. So Kennedy rejects this idea of a general privacy expectation in physical movements. He says that normally the court has said in the past that there is no privacy when someone is moving about in public, where they're in public view. He also says that the Miller and Smith don't support this kind of category by category balancing of privacy interests. Rather, it's a very across the board rule, and the court is not following it faithfully by saying that you need to balance it category by category. And then he says, he points to, again, it compares it. He says this kind of location data, especially at the resolution that these cell site location data is right now, and he makes much of the fact that these don't really pinpoint a specific location like GPS, but they just give kind of a general large range, which may cover many dozens or hundreds of city blocks. He says that that's much less revealing than things like credit card or telephone data. Here's a quote. He says, quote, the troves of intimate information the government can and does obtain using financial records and telephone records dwarfs what can be gathered from cell site records. And he says here the court shouldn't be rushing in to set rules for areas that are undergoing rapid technological change. That's something that's better left to legislative judgments. And here, the legislature has enacted the Stored Communications Act, so that should solve the issue. And he says the majority basically leaves a number of open issues that it doesn't resolve. It doesn't explain what it is that makes something a distinct category of information for purposes of the third-party doctrine. So until now, lower courts have generally applied the third-party doctrine by just a simple rule. Just, is this information possessed by a third party? If so, then there's no reasonable expectation of privacy. Well, what makes something a distinct category separate from, for example, financial records or things like that, that requires a court to kind of rebalance it. He also complains that there's no guidance on how to actually conduct this balance, and no guidance on what scope of collection is acceptable, pointing out that the majority itself says it's not ruling on, for example, less than 7 days worth of collection or real-time collection or these tower dumps. And he also says that the majority calls into question the standard subpoena practice, and the majority doesn't really even consider or address the issue, and just basically it's going to call into question subpoenas in a wide variety of areas. So that's Kennedy's principal dissent. So let me move on to the other dissents. So Justice Thomas dissents. Now, Justice Thomas rejects the Katz reasonable expectation of privacy test. So he takes this opportunity to basically complain that the Katz test is not a good test. He says that this test was basically made up out of whole cloth in the Katz case. There was no basis in prior case law or the Fourth Amendment for using this reasonable expectation of privacy test. And as a result, it treats as searches many things that really are not, because there's no actual search involved. There's just some privacy interest. And he says that basically this test, this reasonable expectation of privacy test that the court has applied for a while, since the 1960s, he says this test, it doesn't fit with basically any of the terms of the Fourth Amendment itself. He says, first of all, this test says it protects an expectation of privacy. But the Fourth Amendment is written in terms of protecting things like houses, papers, and effects, which reflects an interest in protecting the security of property, not privacy kind of broadly. He says that basically this reasonable expectation of privacy reads the terms persons, houses, papers, and effects out of the Fourth Amendment, effectively replacing them with anywhere and anything where someone has a privacy interest. It also, he says, the word "their" it protects people in their houses, papers, and effects, and he says that indicates this doesn't provide protection to other people's properties. And here he says Carpenter can't show any property interest in the cell site data. And so, but the reasonable expectation of privacy goes beyond someone's own, something they possess, their own papers and effects. And also he talks about reasonable. He says in the Fourth Amendment, reasonable refers to the reasonableness of a search. But here it's the reasonableness of an expectation of privacy, which is something completely different and looking at it from a totally different angle. He also says the Katz test, this reasonable expectation of privacy test, is unworkable in practice. He says the court has, this is a quote, this court has steadfastly declined to elaborate the relevant considerations or identify any meaningful constraints. And he argues that there's even kind of two different understandings of the reasonable expectation of privacy test in practice. It sometimes seems to be treated as a descriptive idea. So do people as a descriptive matter actually have an expectation of privacy, a reasonable expectation of privacy? And in this application, when if you're using it as kind of a descriptive claim, it's kind of circular, because whether the courts have found that someone has a reasonable expectation kind of determines whether people actually do have an expectation of privacy. And it also allows circumvention, because if the government kind of does things to intrude on people's privacy, then that reduces people's expectation of privacy. But he says that as it's typically applied, the courts actually apply it just as kind of their own normative judgment about what should or should not be accepted in terms of invasions of privacy. And so he says basically this Katz doctrine, this reasonable expectation of privacy doctrine, should be completely reconsidered. But until it is, he agrees with Kennedy's dissent that that's the appropriate application of the current precedent as it stands right now. I think I realized as I was going through that I mentioned Katz a number of times without explaining what I was talking about. And Katz just refers to a Supreme Court case from the 1960s where they first established this reasonable expectation of privacy standard, rejecting a prior approach which relied largely on property concepts, on a property rights kind of view, and that extended the Fourth Amendment's protection to someone who was speaking inside a phone booth where a listening device was placed outside of that phone booth but was recording that person's conversation. And the court, despite there being not a formal property right, the court said there's a reasonable expectation of privacy in that context. And that kind of established that test. So that's what I mean when I've been referring to Katz through here. I should have explained that up front, but that's what that means. So let me move on now. I've got two more dissents to run through. Justice Alito had his own dissent, and he complains, and he's really focused on this subpoena issue that I mentioned before. He says that this court's decision is really just upending Fourth Amendment law. He says that there's a longstanding distinction between searches and orders to produce information, subpoenas and other forms of compulsory process. And he says, now, because of this decision, subpoenas in a huge number of different contexts are potentially subject to challenge as not being based on probable cause or requiring a warrant. And he also complains, in addition to the subpoena issue, about the failure to distinguish between third-party property. So he goes through a long kind of historic discussion of the evolution of subpoenas, running through, going back into English common law history, but then continuing through the American founding. He notes that subpoenas were authorized in the first Judiciary Act of 1789. That's the act of the first Congress of the United States that established the judicial branch in the first place. And he says that the subpoenas are just ubiquitous. They're essential to the functioning of grand juries, and grand juries were themselves explicitly protected in the Bill of Rights, the right to be indicted by a grand jury. And he says that the history of the Fourth Amendment is clear, that it didn't apply to subpoenas or other types of compulsory process or things like, for example, compelling someone to testify. The Fourth Amendment just had no application to those things. And he says that the court's modern case law, though it's provided some Fourth Amendment protection to compulsory process, it distinguishes between subpoenas, compulsory process, and searches, and has a much less stringent standard for subpoenas, and has never required probable cause. And so he says here the court has basically abandoned all of that history in this particular case. And then he goes on to talk about the issue of third-party searches. Again, he says Carpenter had no property rights in the records. And he says that he characterizes the Miller and Smith third-party cases very differently. He says basically his reading of those cases is that Miller and Smith didn't create some new third-party rule. Rather, they simply prevented the extension of the cat's reasonable expectation of privacy concept to new areas that had been previously unprotected by the Fourth Amendment. So he reads Miller and Smith as just kind of constraining the expansion of the reasonable expectation of privacy idea, not creating some new third-party category. And he basically says there's two possible outcomes of the court's decision today. One of those possible outcomes is that this decision will end up crippling the normal subpoena processes that are involved in all different contexts within the government and litigation and court proceedings. Because if this decision is extended to all these other types of subpoenas, it would just be a radical change to the current operation. But he also says that the other likely possibility is that in future cases, the court will just repeatedly distinguish any future challenges to compulsory process and just continue to find ways why they're different from this case, because it'll have to confront the fact when in future cases that it's disregard for the distinction between subpoenas and searches would have such wide-reaching and broad effects. And then finally, he says that he and this is a view that Justice Alito has expressed in other cases as well. He has a view that really, in these Fourth Amendment areas, legislation should be seen as the preferred way to strike appropriate balances. He says that the legislature is better suited to balance the competing interests and strike a balance. And he said here the Stored Communications Act already did that, and that should be the legal standard. That should have ended the matter. So that brings me to the final dissent, and this is Justice Gorsuch, and he has a very interesting approach. And he basically he divides his opinion is divided into kind of three parts. He says there's really three potential ways the court could go here, and the one is to apply the third-party doctrine, the Smith and Miller third-party doctrine, to resolve the case. The second possibility is to reject that Smith and Miller third-party doctrine and apply the cat's reasonable expectation of privacy standard. So that's kind of the majority, Justice Roberts' approach. And then the third possibility is to reject both of those ideas and go in a different direction. And that's what Gorsuch pushes here. But he first runs through the first two options. First, he rejects the Smith and Miller third-party doctrine. He suggests that this is just, it's a bad guide to people's actual privacy expectations. And it's been justified in various ways, but he doesn't think any of those justifications really hold up. Sometimes it's put in the language of assuming the risk. When you give information to a third party, you assume the risk that it will be exposed to the government. And he says that idea is just a bad fit. Normally, the idea of assuming the risk, it's an idea that comes from tort law and says that if there's some risk that you're aware of and you go forward with some action anyway, knowing that risk is there, then you're assuming the danger of that. But he says that that's not the same as the situation here, when you may have, for example, contracts or agreements with the third party that you're giving the data with that prevents them from revealing that information to third parties. Just knowing the possibility that someone might breach those contractual terms or violate a trust or things like that doesn't mean you're assuming the risk that that's going to happen. He also says that sometimes it's put in terms of consent. But he says this doesn't apply either, because consenting to give data to a third party doesn't imply that you consent to have them further turn this information over to the government. And he says it's also sometimes justified on the basis of clarity. It's a bright line rule. When data is in possession of a third party, then the Fourth Amendment doesn't apply. And here's a quote here. He says, quote, "You, and the police know exactly how much protection you have in information confided to others. None. As rules go, the king always wins is admirably clear. And he goes on to say that just the fact that it's clear doesn't mean it's right. And you could make the argument the opposite way, saying that the Fourth Amendment should always apply when it's data's in the protection of in the hands of a third party, and that would be just as clear. So there's no reason there to prefer one side of the one side over the other. So he goes on from there to discuss the CAT's reasonable expectation of privacy standard. And he complains on several grounds about that. He says that this standard is not grounded in the Constitution or early American history. And he points to Justice Thomas's discussion for that. And he also says it's just not clear what it's supposed to measure. Is this an empirical question, whether people actually have an expectation of privacy? He says if it is, well, first, there's no evidence that it actually matches people's real expectations. And second, aren't legislatures better situated to kind of study that question in detail and come to a better decision on what people's actual expectations are than the courts are? But in fact, if it's actually a normative question, if it's a policy judgment over kind of what people should be able to expect, what should people reasonably be able to expect as far as their privacy is concerned, well, if that's a matter of pure policy judgments, then that's something that is definitely better suited for a legislature rather than the courts to decide. And he says, he also says that the actual application of the CATS test is unpredictable and unbelievable. And he points to certain results that the court has found under this reasonable expectation of privacy test and says that they're frankly ridiculous. And here's a quote from his case. He says, quote, "Take Florida v. Riley, which says that a police helicopter hovering 400 feet above a person's property invades no reasonable expectation of privacy. Try that one out on your neighbors." So that's a good line he has there, but pointing out that it has resulted in some kind of unexpected results that probably would not fit with most people's intuitions about what a reasonable expectation of privacy is. And then he complains that here in this particular case, the court just provides very little guidance about how it's supposed to apply. What level of access to someone's information becomes an arbitrary exercise of government power? When does surveillance become too permeating? And he says that the court, the majority refuses to answer some questions that to Gorsuch it seems like should be pretty basic. So, for example, what about a shorter time frame? If this hadn't been 7 days or more of collection, but it had been a shorter time frame, what if someone was seeking real-time location data or these tower dumps? The majority just won't even answer those questions. So he thinks this CATS standard just should be rejected and is not the right way to go. So having rejected the other two approaches that the majority and the other dissenters have advocated here, where does Justice Gorsuch go? He advocates something that's become known as the positive law model. And this is basically the idea. Positive law, it's the idea that the laws governing people's general actions, and this would include property law, but it could also include other statutory law that provides people with certain types of privacy protections. That law, referred to as positive law, is a law enacted by legislatures or by courts acting in a common law fashion. That positive law would provide the baseline for Fourth Amendment protection. Now, he says that this model, this has been advocated by several academics in recent years and has gotten a lot of attention as kind of a new approach to Fourth Amendment that's attractive to many people with kind of a formalist bent who like using formal legal categories to resolve a lot of constitutional questions. And Gorsuch says that there's this model, there are a lot of open questions about the application of this model that still have to be answered. And then, but here's a quote. He says, quote, "I do not begin to claim all the answers today, but unlike with CATS, at least I have a pretty good idea what the questions are." And then he goes on to kind of run through what he sees as some of the implications of this positive law model. He says, he goes through a bunch of them. He says, first of all, he says that third parties' access to information doesn't eliminate property interests in it. And he refers for that to a very old property concept known as a bailment. That's the idea of when property is given to a third party to hold for some purpose. Sometimes that's for the third party's purpose. Sometimes it's for the purpose of the person who's giving that property. And it's a very old concept that actually goes back to all the way back to ancient Roman law. And he says that this concept, it's a very old property concept, and it's already reflected in some parts of the court's Fourth Amendment law, specifically the law of mailed letters. When you mail an enclosed envelope, the government is not allowed to open and look inside that mail because it's protected. And even though the government is in full possession, so you've given this to a third party. And he says this is an example of a bailment where the fact that the government has possession of a third party doesn't remove the privacy protection that comes with from the sender of that mail. And he also says that complete ownership and control is not necessary for Fourth Amendment protection. And here he points to houses and says that houses are protected, and tenants who do not own the property or resident family members still have Fourth Amendment protection, even though they don't have ownership of the property in question. And he also says, in going through that, he says that the fact that you have to surrender possession for some purpose doesn't mean you're giving up all rights to it. So then he goes on to say that positive law, so statutes and things like that, can provide detailed guidance without having to rely on judicial intuitions. And he says that state law is often actively providing new protections, both through common law development in state courts and through legislative action, to protect people's privacy in various different ways. And that's just an ongoing practice in various different places around the country all the time. And allowing that to play out and allowing for example, a state government to pass laws prohibiting cell phone providers from using data in certain ways, well, that would create a new positive law baseline that would guide the Fourth Amendment inquiry. But on the other hand, he says that although positive law could create new protections, it can't always destroy existing protections. For example, he says the government couldn't pass a law authorizing mail carriers to open people's mail because that would invade what is otherwise a floor, a constitutional floor that people have. So he says that there's a limit to the extent that the government could destroy protections that otherwise would exist. And he also, building on that idea, he says that this idea of a constitutional floor could bar the use of compulsory process. So this is returning to that idea that Justice Alito was talking about a lot, the use of subpoenas and other compulsory process. This idea of a constitutional floor could bar using that kind of compulsory process to circumvent what the Fourth Amendment will otherwise protect. And he again returns to the idea of mailed letters and says you couldn't issue a subpoena to a postmaster to have them turn over all of someone's letters. Because that would just be an end run circumventing around the protection that otherwise exists there. And then going on to the facts of this specific case, he says, quote, so one question you may have is, given this discussion by Justice Gorsuch, why is this a dissent? Well, he says, quote, it seems to me entirely possible a person's cell site data could qualify as his papers or effects under existing law. But Justice Gorsuch's issue is, he says that Carpenter never made these arguments in the lower courts. He says, quote, before the district court and court of appeals, Mr. Carpenter pursued only a cat's reasonable expectations argument. And he basically says that even at the Supreme Court, this positive law argument was only made in kind of the most cursory way and wasn't really developed fully. So he says, given that, he feels that he can't decide it on those grounds. In this case, he says essentially Carpenter basically forfeited this argument that Justice Gorsuch would have been very receptive to, forfeited it by not fully arguing this idea and making the case under this positive law model. So this is basically Justice Gorsuch's indication to future litigants that if they want his vote in Fourth Amendment cases, they should really be making this positive law argument. So this is almost certainly this is an argument that's going to keep reappearing in the future, if only because litigants want the possibility of winning Justice Gorsuch's vote. Whether it has any appeal beyond Gorsuch and anyone else is willing to adopt this is more questionable and just remains to be seen in the future. So that brings us to the end of the 4 cases from Friday. Again, the court issued 2 more cases this morning, along with granting some new cases for next term. The court has 4 more cases, some of which will be issued tomorrow morning, and we don't know when the court will finish off, hopefully Wednesday. Again, the tentative plan is I intend to have another one of these live streams Wednesday night at 9 p.m. That's Wednesday, June 27th at 9 p.m. And the hope is to cover the 6 opinions, the remaining opinions, cover all of those, assuming they're all issued by Wednesday, and get all of the opinions out of the way. And then I'm hoping to have another live stream at the normal weekly time, Thursday at 9 p.m., to kind of wrap up the year. And in that one, I'll cover the new cases that were granted for next term and just some other orders and developments at the court. And kind of wrap up our coverage of this term and do a little bit of a look ahead to next term. And a reminder, the 6 remaining cases still are, well, 2 cases were issued this morning. The 4 cases that are still outstanding that haven't come out, there's still several major cases among those. One is NIFLA v. Becerra, which is a case about California's FACT Act, which is requires so-called crisis pregnancy centers to provide certain disclosures about the availability of abortions. That's one that's it's kind of another, because it involves abortion, it's another highly contentious political issue, kind of falls under the culture war category. But there's 2 other cases. Janice v. Asks Me. This is a case about union collective bargaining fees, and depending how it comes out, could kind of have a major effect on unions' abilities to collect fees from non-members who are represented in collective bargaining. So that's a big case that's kind of highly anticipated and people are really waiting for. And then the final one is Trump v. Hawaii. This is the travel ban litigation about the legality and constitutionality of President Trump's travel ban, the ban on entry into the country by nationals of certain countries, and those are all still, in the next few days we should be getting all of those. So still a lot of kind of high-profile cases still waiting out there. So I hope you'll join me Wednesday and Thursday night to go through the rest of these cases and kind of wrap up the term. Whether you're watching on YouTube or listening to the audio podcast, I would love your feedback. You can leave comments on the show notes at countingto5.com, on the Counting to 5 YouTube channel or Facebook page. You can tweet at countingto5 or send an email to mike@countingto5.com. Please subscribe to the Counting to 5 YouTube channel or audio podcast to make sure you don't miss future episodes. And thank you for listening. This has been Counting to 5.